This is Craig Huston, your Summit Series host. Welcome to our podcast. The Summit Series is your behind-the-scenes pass to building real value and preparing for what's next, whether that's scaling, selling, or simply stepping back and enjoying what you've already built. Let's dive into what actually drives great outcomes and how you can make them happen. I'm here at the law firm of Tripp with Dennis Smith and Mariana Seiler-DeJager, and we're here to talk about the 5 Ds. Those things that can really be impactful negatively or positively on a business, depending on how a business owner handles it. And so welcome to you two, or thank you for welcoming me into your place. It's actually the other way around.
We're happy to be here.
Yeah, and we are happy for you to be here anytime you'd like, right?
I appreciate that. Thank you, Dennis. So the 5 Ds are death, disability, divorce, disagreement, and distress in business. A phrase that, as far as I know, was coined by Scott Schneider and Chris Schneider with the Exit Planning Institute. But when I work with clients, and whether they're planning on an exit or just trying to build a good business, oftentimes I find that they don't have their house in order from a documentation standpoint, legal documents, insurance, things like that. And so this all falls in the category of de-risking your business. And so what we want to do is equip business owners out there to be able to make wise decisions and have the right stuff in place, and hopefully hire the right law firm to help them out as well. So Dennis, I'll get started with you. Talk to me about the death of an owner and the impact that might have on a business and how they can prepare for it.
The death is actually, among your 5 Ds, in my view, is the easiest one with which to deal from a global picture. The easiest way to try to make sure you're protected is to buy life insurance. And the only time it's a problem is if one of the owners is not insurable. But assuming they are buying life insurance in an amount that's equal to what they agree the business's value or that owner's business value is, so that it's a simple thing. Unfortunately, when one of them may die, the money comes in and it's paid to buy the ownership. Mm-hmm. That then allows the surviving owner to find somebody to replace the person who has passed, if that's what they want, or to keep it themselves and find the skill level that they're comfortable with going forward. So the big thing that happens to the company is they lose the skills of the person who died. But as long as you get life insurance and you have a binding buy-sell agreement, you don't have to worry about all of the bad things that can happen with somebody passing away. Now, if you don't do that, the bad things are bad things, because that means the stock is going to go, if you don't prepare, the stock's going to go into the deceased shareholder or owner's estate. That means it could go to their spouse, who may have no idea what your business is, and they become an owner. It could go to their children. It could be sold. And you get a new partner that you didn't expect to ever have, who may believe the business should be run totally differently than the way that you as the survivor want it run. So there's all kinds of bad things that happen to the business and the potential of it being successful that are completely out of the survivor's control if you don't plan properly. So you want to plan, and it's easy to plan. So there's no reason for you to fail to do it.
Yeah. Do you have an example of, without divulging any client information, do you have examples of businesses that you're aware of that failed to plan in this area, where it was a bad outcome?
Yes, and I could give you a number of them. Fortunately, they were not our clients before one of the deaths. The survivor came in and became the client. Unfortunately, they were at a point at that stage where the stock, they were 50-50 owners. One of the owners died. The family, particularly the spouse, then got the shares, and that wife wanted distributions constantly, didn't care if the business grew, didn't care anything, didn't know what the business really was.
Yeah.
And she was being incredibly demanding of, well, if you don't distribute, I'm not going to vote for this, and I'm not going to agree to that. And so there was, the survivor ended up at least getting her to agree to sell. And they sold the business. They probably could have gotten more, but everybody knew why they were selling.
Yeah.
So there was a discount applied, and we helped them sell, but that wasn't what would have been the best thing for the business. So they lost their business because they didn't prepare. And had they prepared and just bought life insurance on this other owner, would have been no problem, and things would have been able to grow however the survivor wanted them to grow.
Now this might be a good place to kind of segue into a buy-sell agreement.
For sure.
What kind of terms well, first of all, let's tell everybody what a buy-sell agreement is and why you would have it in the first place. And then what are some of the key elements that an owner needs to make sure are in that agreement and spelled out very clearly?
Well, there's a bunch of things. A buy-sell agreement is an agreement between the owners of the business on how they will sell in certain events. It can be voluntary sales. It can also be involuntary. So it would deal with, in the case of death, in the case of disability, in the case of a disagreement. So you can build all of those types of resolutions into your buy-sell agreement. We don't actually call them buy-sell agreements. We call them shareholder agreements or partnership agreements, or whatever the entity is. We call it that kind of an agreement because it's more than just buy-sell. It encompasses a lot of other issues that you will resolve in your written agreement. Okay.
Now, what about payout terms and things like that? I imagine you have this insurance policy so that you can pay out to a spouse.
And you don't burden your company.
Yeah.
And that's the key, is with life insurance. You can fund it 100%. The family, gone. And you don't have anybody watching over your shoulder that doesn't know what they're doing anyway.
Yeah.
And so you then own the business 100%. You're not burdening the business with payments that the company is still obligated to make that would be wasted money for the company, frankly. Instead of spending it on the current company things, they're spending it on past.
Yeah.
And that is not always the best interest of the company.
Yeah, absolutely. And Mariana, how about you? What have you seen in this area?
A lot of different things. So especially with what Dennis said, sometimes you get clients who come in, maybe it's too late to buy a life insurance policy, maybe they have certain health issues that they weren't able to buy a life insurance policy at the time. And so we've actually documented situations that cover for that as well. So if they weren't able to use a life insurance policy, or maybe it's smaller than what they thought the business should be worth, we do put in their payment terms of how can we address this going forward? How can we make sure that those people are out of the picture and potentially have some sort of payment plan that doesn't make it harder on the company going forward? We actually recently had a client come to us, said that they were actually the sole owner of the business. So that was something that we've had to find a solution for. And we were able to do documents for a succession plan, determine who is the next potential operator of that business, and how do we make sure the business does benefit the estate of the person if they pass away, but not affect the business's kind of continuity and make sure it can continue to operate successfully. Unfortunately, in that situation, the person passed away prior to documenting all of those things, and we're seeing the ramifications of that now. So we're seeing the business, while that manager has taken over, is able to kind of pick up the pieces and operate where they can. They weren't able to do it right away because of certain things that needed to be done with the bank and with the other business accounts. Mm-hmm. And so we actually saw a few of the clients move on from that business. We've seen them go other places, and that business is losing some of its value, affecting the value of the estate for that person's family.
Yeah, I mean, that's tragic. This is a new question kind of coming in, but working in the philanthropy space for a long time and working with families that plan out their estates and their giving and you know, what they're leaving to people as legacy. So many times documents are drafted, money is spent on attorneys, but they're not executed. And if you were going to say something to a business owner about that, what would you say about that?
Come execute your document.
Yeah, come execute your documents. I mean, we pester them, and they still sometimes, there is a strange thing sometimes, Greg, that you have to deal with, and that's people know they need wills. They know they need shareholder agreements. They will come in and they will sit with you and talk with you about it, but at the end of the day, some of them have this absolute belief that if they sign it, they'll die.
Yeah.
And they avoid signing it for the silliest reasons.
Yeah.
I've never had one, by the way, that once they signed it, they immediately died. Never had one do that. And but they're scared, some of them.
Yeah.
The other ones just procrastinate because they don't want to sign something and make a mistake. They view it, especially shareholders agreement, as once they sign it, they're stuck with it. So if they screwed up somehow and their partner, is going to get an advantage somehow, they're now stuck with this. Well, to be honest, they're better off with the partner getting a little advantage in a written agreement that says what's going to happen than not having one at all.
Yeah.
But they're willing to do that.
Yeah.
You'd be surprised how many people either come in and say, I'm ready to do this, and then 3 months go by, 6 months go by, and they haven't come back to finalize it. Or that say, I have it all documented, I'm ready to come in and sign. And a lot of that is the nature of the entrepreneur, right? It's of that closely held business owner. They're thinking about their business around the clock, and they think, oh, I'll get to the legal issues when I have time. But what they don't realize is that is probably one of the most important things to address as part of their business. They think of it as, oh, it's for the lawyers. It's not. It's really to make sure
For
your
the family,
business
yeah.
can succeed and your family can be protected down the road.
Yeah, absolutely. And you said, at least to your knowledge, but
Nobody has.
statistically, it probably happened somewhere, sometime in history,
But not
that
to
somebody
us.
signed it and had a heart
Not
attack.
to us. The thing, though, Greg, that I want to emphasize is what Mariana said, and that was this owner who was a single owner, owned 100%. And he moved once he decided to do it, he was actively moving down the path. And it was almost all ready to go, and he passed away unexpectedly. It wasn't, and that can happen. So he hadn't signed anything and he passed away.
Yeah.
So he would have been better off had he signed it, then he wouldn't have passed away.
And for the people who are listening to this, stats haven't changed. 100% of people who don't sign still die.
They still die. Yep.
Yeah. Ultimately, it's going to happen.
Eventually,
And you just
one
want
day.
Yeah. So you want to be prepared. A big thing in the 5 Ds is disability. So what steps should a business owner take to be prepared for mitigating the risk of disability?
Disability, to me, is the most challenging thing to address in a company because I can tell you, I had a typical company owned by 2 guys, and there was one of them was Mr. Inside. He did all of the administrative work. He ran all the crews, did all of the inside work, and his partner was the marketing and sales guy. And he would go out and sell their jobs. He would design. He would do all of that work. Well, they didn't come in to get any planning done, no matter how many times I asked them to do it. And lo and behold, the outside guy got sick. He didn't die, but he got sick. Well, they had life insurance, but they didn't have disability, either income disability or disability buyout insurance. As poor as disability buyout insurance is, they didn't have any of that. And here's this guy who is living, but he can't work. Well, Mr. Inside only owned 50% of the company. Mr. Outside owned the other 50%, and he still wanted all of his pay. Okay? which if he, and the Mr. Inside then had to not only do his job, but he had to do the marketing and sales, at which he was horrible as well. So the business started to go backwards. And so now Mr. Outside is starting to threaten a lawsuit because the other guy is not running the business right. And so things just started to deteriorate from there.
Yeah.
And it ended up that they finally agreed to put the business up for sale, and the person who was disabled was able to at least get a pop of cash, and the guy that almost had a heart attack because of the stress, Mr. Inside, sold. So what would be the solution for them? What should they have done? What I tell people, and I would tell you, is they should have bought a disability income plan. They should have bought life insurance before the issues came up, because they could have gotten fine amount. And then when the outside guy became disabled, he would still have his income. He would have it from the disability income plan. The company wouldn't have to fund that. So the company could hire somebody to replace him in sales and marketing, and for less than what this guy was making. But the guy was fine because he had his disability income payments. And then normally, this is going to be a strange statistic, but normally people that go on long-term disability don't live that many years, probably 2 or 3 years. And which is why long-term disability income insurance is so cheap, because they're not on it that long before they pass away. Well, then you have the life insurance, and it's a death buyout then, because you have put it off by having the income come to him, and then you have the life insurance that when he then dies, the life insurance funds it, and you do a normal buyout with the shareholders agreement causing that funding. The Mr. Inside never has to give up the business, will own 100% once his partner dies, and he will have replaced that partner with an employee that's doing the sales and marketing, and the business will be fine. So there are solutions, but people don't tend to take advantage of the solutions that are out there, and that's why that one's the hardest, because you have to combine a few different elements to make it work.
Yeah. Well, also, I think something like that, if somebody's feeling healthy, they're probably reticent to go seek insurance, and then when they need it, they can't qualify.
They can't get it.
Yeah.
Right.
So in my work in philanthropy with the community foundation, we worked with a lot of families who were doing legacy planning, building out their estate plan. And one of the things that we noticed were a lot of people had spent a lot of money, a lot of time, a lot of conversation with the families, drafted documents, and failed to execute them. And then something unfortunate happened. So all of that work was for naught, and it ended up going through probate. And instead of their favorite charity being their greatest contribution, the IRS became one of their larger contributions, unfortunately. But when you look at the perspective of a business owner and an estate plan for the business, for the family, what are some of the key elements that should be in place for every business owner, regardless of the size of the business, and for every family, whether the person has kids, doesn't have kids, is married, isn't married, what might that be?
Well, first and foremost, a will, right? What happens to the specific assets at the time they pass away, depending on the size of the estate, and if they have a business, usually a trust, sometimes more than one trust. Often our business owners have at least one trust, and then depending on, like I said, the size of the estate, there's different tax planning mechanisms we use to have multiple trusts in that scenario. From a business side, it's really back to that buy-sell piece of the operating agreement or the shareholders agreement, and we put those death provisions in there. And actually, Florida law now allows a beneficiary designation in your operating agreement. So it's an attachment to your LLC or operating agreement, and it has the same requirements as a will. So it has the signature of the person, the notary, and 2 witnesses, and that actually supersedes the will if it was signed after the will. and allows for the transfer of the LLC interest. That, I would say, in conjunction with kind of the succession plan of what they want the business to look like after they pass away or as they're kind of drawing back from the business, retiring, things like that. Those are all part of the big picture estate plan of your business. I don't know if you would add any.
Yeah, the things I would add is you have to look at who owns the business, assuming there's a business here. Mm-hmm. Is it one or two or three closely held type owners? If it's one, then you have a real issue, because if the predominant person who is running that business dies, what they needed to do was have a successor, mm-hmm. potentially a family member, be in that business earlier on so that they can learn it and continue it after the death of the primary owner. If that's what you want, you can still have it in a trust, and you can still have the earnings be beneficial to all the family members, but you need that successor. If, in fact, you don't have one, then you need to put in place who is going to help sell it when you die. Because you only really have two choices. One is you pass it on or to your family, or secondly, and I usually recommend it be one person that gets the majority ownership. You can have more that get minority ownership, but you want one controlling party. It eliminates a lot of the disputes that tend to go on with multiple family members. And so you have to decide. And if you're going to sell, then you need to make sure you put, maybe an appropriate one, not to push lawyers, but your lawyer might be an important person to be a trustee, along with one or two of your family members, to be able to really guide the direction of packaging and selling that company. So, you need to go beyond just the will and the trust. You need to really focus on the business and how you're going to pass that business along by either selling it or having a family member take it over, right?
Okay. Yeah, no, it makes a lot of sense. I want to make sure I include everybody. So there's the person out there who had this great idea. They started in their garage and it took off, and they've been hanging on for dear life ever since. They can barely remember what day of the week it is because they're so busy. This happens quite a bit.
Yeah.
And honestly, they haven't even remotely thought about this. At some point in time, somebody gets into some sort of business networking group, or they get involved in a trade association, or some sort of pure type of coaching group or a mastermind or something like that, and then they start to get exposed to this. But at what point in time does that person who's hanging on for dear life need to learn about this and need to start taking action?
I think they need to learn about it when they're starting the business. We do get a number of people who are starting their business that ask us to help them on the initial setup. And if I'm doing one of those, I raise that issue up front, that what they need is to make sure they target people. That somebody that you're talking about is kind of the thinker, but he may not be the best operator.
Yeah.
And many times, I always laugh about this, but most entrepreneurs tend to have a very flat reporting structure. There's them, and then everybody that works for them reports to them. And so,
true, that's very true.
Yeah, well, that's not good. That's bad, because that's why they can't see. That's why they are buried and can't even find time, to sleep, because that's their reporting structure. What they have to do is recognize as early as they can that they need to insert a manager, somebody that may not be the best at knowing the business, but they are the best at managing people.
Yeah.
And so you don't cut him out of that. You make him what he needs to be, and that's the brains. But you need a manager, and somebody steps in as the manager, and then may have one or two layers of reporting, so that you have the ability. You should never have, my opinion, more than 5 people reporting to you. I think once you get above that, you start to get into this struggle if you've adequately assigned the appropriate work to those 5,
Yeah.
then that's just my opinion though. So you need to help them through that.
Mm-hmm.
And we will, especially, Alamo Rent-A-Car. Mike Egan was the entrepreneur. He needed people so he would bring in chief operating officers or actually CEOs that would report to him,
Mm-hmm.
and they would manage the business. They would organize the business.
Yeah.
And he was the one who was like, well, okay, here's what we got to do. And here's how we do this. And here's how we do that.
Yeah.
And so he was the brains.
Mm-hmm.
But the managers were the people who were able to implement it.
Yeah, 2 types of brains, right? The visionary who sees all the possibilities.
Sees it all.
Sometimes way too many possibilities. And then the technician or the technical person who can run the business and do operations.
And that
sometimes too technical, sometimes too fixated, but
Well,
it's a balance of those 2, right?
Yeah. While we would love to do it from the start, like Dennis said, right? Sometimes it's not possible, but it's never too late. So I would say from a timeline
It's never
perspective,
too late till it's too late.
Yeah.
till it's too late, right?
Yeah.
But from a timeline perspective, if they're thinking about it, that's the time. So as soon as it's brought to their mind, I know some people say, well, I was worried, I didn't want people to think I didn't do it correctly. We'd rather you come to us or go to an attorney and say, what do I need to do?
Yeah.
And our entire job is putting together puzzle pieces of your life, right? Whether it's puzzle pieces of your business and puzzle pieces of your estate, it is that puzzle. And so it's a lot of fun to do it at any stage of the business.
Sure. And I think along those lines, when it pops into your mind, there's a reason it's popping into your mind. Something's back there in your subconscious starting to gnaw at you, and probably something.
Or they went to their doctor and they're really under a lot of stress.
Yeah.
And the doctor is saying, you need to stop being under this much stress.
That's right. That's true.
Things like that are actually really happen.
Yeah. And one of the things I want to do is hit the owners right where it hurts, and that's the value of their business. And so when people are doing all things, that they own all the customer relationships, they are the key employee, they make all the decisions, everybody reports to them, that business isn't worth a whole lot of money. Because if anything were to happen to that person or that person exits the business doesn't function. So the sooner people can learn to delegate and have a structure in place and procedures in place and playbooks in place, the business starts to take off.
Yeah.
And they find out they can enjoy life a little bit.
They can take a vacation.
They can take a vacation.
I mean, that's the beauty and the pain of an entrepreneur. The entrepreneur hates to give up control of anything.
Yeah.
On the other hand, as soon as they do, they actually do way better. Because there is a limit to how much stress you can put yourself under with everybody reporting to you.
Mm-hmm.
You do have a limit to how many people can be in that situation.
Yeah.
But if you insert some management, you don't have a limit. You can build it, and so once they realize that, they can build a much bigger business and do much better when they do that. And as you say, it becomes worth a lot more money because it's now not about him or her, it's about what the business does.
Yeah, it becomes value creation,
Yes.
for sure. I have a client that has a number of shareholders, and 2 of them have gone through divorces recently, and the business over the course of time has increased dramatically in value. So we all think, when you're at the altar, this is forever, and it's nothing bad's going to happen, but anything can happen. And unfortunately, sometimes it does. So in the case of divorce, what would you recommend for a business owner to prepare themselves and mitigate risk for the business?
There are a few ways we do this, right?
Mm-hmm.
One is a prenup when they're getting married, making sure if the business is already in existence, making sure they document it in some sort of document with their spouse, which is called a prenuptial agreement prior to marriage. If they've already been married, a postnuptial agreement is also an option. But one thing we see the most is when we're doing kind of corporate documents, it's called a spousal waiver. And as soon as, say, you sign the operating agreement, we have your wife sign the spousal waiver. And it basically says that in the event of a divorce, I'm waiving any rights I might have to this entity. When that's forgotten, often the business gets pulled into somebody's divorce case, and that's the last thing you want.
Yeah, that's horrible. You can also put it in the shareholders agreement and have the spouse, male or female, sign. And that doesn't mean that they have to give up the interest. The spousal waiver is asking them to give up the interest that they might otherwise have. You can also do it so that they agree that they can be bought out for X price, and they absolutely agree to do that. I mean, we've had situations where they didn't have one of those, and the spouse refused to sell. They just wanted to sit there as an owner, and it didn't matter. They were going to sit there as an owner, and then they started demanding to get money dispersed to them, which under Florida law, they don't have any right to demand that unless it's really excess capital. But that doesn't stop them from threatening and from arguing mismanagement and all this other stuff. So you want to get the spouse, whether it's, because I always have a concern about a prenuptial, because the parties can waive that. And they can waive it by the way they title things. And the husband or the wife who's starting the business could actually just issue the stock tenancy by the entireties, because somebody told them if they own a tenancy by the entireties, their creditors can't touch it, which is true. I'm not suggesting that that's not a true statement, but they can sit there and say, oh, I think I want to protect myself from liability, so let's put it in tenancy by the entireties. Well, as soon as you do that, the prenuptial doesn't apply anymore to that asset. And so I tend to like doing it in either spousal waiver or doing it as part of the shareholders agreement and have both parties sign, because you're just going to force a ability to buy them out. And so you're not screwing them, you're just getting them out of the business.
Hey, thanks so much for listening to this episode of the Summit Series. Please make sure to click on the follow button on your podcast app so you never miss an episode of our show. This episode was produced by Paige King and was edited by Matt Huston. I'm Craig Huston, and you've been listening to the Summit Series.